The Mortgage Mediator Certification Training is now offering Session 5, Bankruptcy Court-Ordered Mediation and the Mediator's Role. There will be 2 speakers. The first will be Terry Smith, who is a standing Chapter 13 trustee in the Middle District of Florida, Tampa Division. He is one of 2, and Terry has been a trustee in Chapter 13 since 1993. Previously, he was a Chapter 7 trustee for 5 years. His prior work experience includes being a public accountant, doing mortgage brokering, banking, and teaching. He has a BA with high honors from Michigan State University, acquired that in 1968, and an MBA from Wayne State University in 1976. And he's been a CPA since 1971. So introducing Terry Smith, who will speak to us prior to another trustee, a Chapter 7 trustee and mediator, Tracy Stevenson. I'll introduce her subsequent to Terry Smith's presentation. Thank you.
I've been I celebrated the 20th anniversary of my position as a Chapter 13 trustee May 1. And I was a 7 trustee for 5 years prior to that. Never been a mediator. I doubt if I'd be any good at it. You know, I consider myself the, you know, since I have a substantial office, there are 2 trustees in this jurisdiction, John Waggy and myself. We both have approximately 13,000 cases each. So I have 13,000 debtors writing me a check every month with large numbers of creditors being paid on each of those cases. I distribute about $7 million a month. I have a staff of about 40 people. We're busy. We have 13,000 moving targets. And I describe myself very illustriously as the plumber of the bankruptcy system. And somebody said, well, why would you describe yourself as a plumber? I said, well, it's my job to keep the crap moving. Because everybody is much healthier when it flows through the system.
Why the introduction?
And people went, that's probably really not a bad description. And you guys are part of that process. You're part of the crapshoot. Yes, because a major portion of our cases now, we have debtors trying to get their mortgages modified. Do you have the power? You have
Yeah, it's warming up.
They're warming up. Because basically, in my concern with the mediation modification process is I think too often we have debtors who come into the mediation with a preconceived notion that that lender's going to sit down and going to listen to them because, by golly, they got a court order requiring them to be there. And I know that's not the fact, and I know all of you know that's not the fact. But the debtors come in with these preconceived notions that, well, they're just going to get a better deal out of this situation. Mediation in bankruptcy was started by Lori Weatherford. Did any of you work out of the Orlando area at all? Lori's judges jumped, when they saw the mortgage crisis come down, they jumped on the idea of doing mediation to get these mortgages modified. And Lori set up a process and has been very successful in implementing it. Her caseload has jumped significantly. And Mr. Vaughn, you'll get a kick out of this. Interestingly, as far as bankruptcy goes, Orlando was a higher bankruptcy filer in Chapter 13 for about a 3-year period, higher than Orlando, which doesn't make any sense. Fort Myers, Orlando, totally different size, but Fort Myers dominates. Now, with Orlando's mediation process, it's working much better. Lori a lot of debtors are filing strictly to get the mortgage mediation modification going, and that's where all of you guys come in. Both Lori and I use an order establishing duties. That's an order entered in every case. In every case, it tells the debtors and the creditors that what is going to happen. In both Lori's case and in my case, it says if you are going to ask for a mortgage to either cure arrearages, which you guys don't get involved with, and pay the adequate protection payment, if the debtor is going to put that on the plan, he must make the adequate protection through the trustee, and the trustee will make the adequate protection payment as well as the arrearage payment. In the modification process, if you're going to ask for a modification, you have to commit 31% of your gross income as an adequate protection payment to be going to the lender while you go through the mediation process. And a lot of people jumped on that and said, well, that's great. I'm applying 31%. I make $10,000 a year, and I'm certain I can afford my $400,000 mortgage. Hello? You couldn't afford it when they gave it to you. You can't afford it now. But I'm certain you are seeing some of those mediations where you're looking at debtors who make absolutely no money, but they want to save a house that they never could afford. But the whole idea is reality needs to sink in somewhere along the lines. And I know, I've just sat in here for a little bit, you guys aren't reality specialists. You're mediation specialists. I've been doing this so long, I have sort of a devil-may-care attitude. When people sit down in front of me, I will look at them straight in the eye and say, dump your house, move on with your life. Now, you don't like to hear that if you want mediation business. And initially, that caused some problems with my judges because I've had numerous debtors who haven't made payments for 5 years. And interestingly, a lot of times they didn't make payments for 5 years because they didn't know who to make that payment to. And you say, well, how's that possible, Terry? Well, let me give you an example. And this is not one, I'll give you one example, but it's an example I see over and over and over again. And that is, a case is filed. The debtor's either going to mediate or pay the arrearage and pay the adequate protection payment. They'll make payments to me. A creditor files a claim. I'll be making payments. I'll make these for, if it's a mediation case, maybe for up to a year before, because it can never find anybody to mediate with. Even though someone filed a claim, the person who filed the claim said, well, I wasn't hired to do any mediation. You need to get somebody else. And in cases of arrearages and adequate protection payments, I paid as much as 2 to 3 years. And then I'll get all the money back that I've sent out. In one case, $28,000. It came back. And they said, we sold that mortgage 2 years ago, and we can't do anything with any of these payments. And I said, okay, here's a good question. Who did you sell it to? And their answer was, we don't know. That's exactly right. You guys have heard that. We don't know. You're now a debtor's attorney or a debtor, and you're going, what do I do now? Or if you're trying to get a mediation going, well, who do I mediate with? We don't know. We've actually completed cases. We've actually held 5 years of payments on a mortgage, have made them and had them sent back for 5 years in a case. At the end of the case, still no one has raised their hand. And we actually asked the debtor's attorney at this point in time, ask the court to have the money turned over to the debtor. And the debtor just gets the money back. Someday, somebody may knock on your door and say, I have a mortgage on your house. But those are the issues I'm dealing with. Now, you guys are hopefully dealing with the issues where we actually identified a mortgage company and we're trying to get through the process. And, you know, when she asked me to speak at this, I said, why do I don't want to speak at this? I said, you know, but I understand, you know, you're part of the Drano to keep the stuff moving through the system. And that's what I'm looking for in the mediation process. All I care about mediation is the parties get together, you know, the lender party has somebody they can talk to, can tell a debtor, this is the information I need. The debtor, get it to the debtor, and have the debtor give the information they need. Then they can sit down with you guys and talk. And that's where you guys fit into the process. Now, were most of you involved in the state court mediations?
Many, yes.
Let me ask you a question. What's the difference between the state court mediations and the bankruptcy court mediations?
Two different courts?
Two different courts, okay. Does one work better than the other or not?
Yes.
Why? Which one and why?
I don't know.
Lenders take federal court seriously.
Because we've heard that's the situation. We don't know that to be a fact. I don't get it. Why would they do that? Now, I assume you've all seen the Orlando case where Judge Geneman sanctioned Bank of America, wasn't it?
Yes.
Basically the amount of their mortgage for failure to follow court orders. Don't know where that's going to come out.
It's, generally speaking, the lender gets a better deal in state court if they go to trial. I mean, they can foreclose on the house. In bankruptcy, it's not a sure thing. And, you know, you're playing in federal rules, and it's, they get sanctioned more often.
Let me make a, excuse me, comment here. Obviously, the issues regarding discharge and the fact that the debtor is going to have, and it was brought up to me earlier, a whole lot better credit report once they're through the Chapter 13, or even if they file a Chapter 7, of course, they're discharged, but there is a Chapter 13 discharge as well. That has a big effect on it, too, from a very practical standpoint. But from a standpoint of courts, I think what I'm hearing Terry alluding to is that the courts are not putting up with a lot of game playing. When Bank of America, in that case, I think it's Hoagland, Houglan, if I remember the name of it right, when Bank of America did not appear at a number of hearings that were scheduled and then violated an order, violated the plan, I guess, the way the plan was already confirmed, and then they came back and the payments were being made, and then all of a sudden they sent another notice that said, oh, I'm sorry, we're not going to honor that anymore. We want you to pay something else, right? And then they don't show up at the hearings. Finally, the judge just, after like a few hearings, just issued this order that said, you are now being sanctioned, the amount of the mortgage, amount of the debt, and then the mortgage, if you record this order after 30 days, I think, 30 days, will eliminate the lien. Record the order on the public records, and that will extinguish the mortgage on the public records. Well, after that, there was a response.
Really?
Darn. Yeah, see, the plumber. Anyway, after that, there was a response, and there is a hearing scheduled in June on their response. And the response is very technical. response related to service process and whether it's a contested matter versus a case, part of the general case. So it's that kind of thing. Because there's no excuse, well, there's no claim that Bank of America didn't do what it's alleged that they did. All right, it's just a matter of what's going to happen about it. So, but what's happening here, and it's what I'm seeing quite often, knowing both jurisdictions between state and federal, is that, and the reason I think that George mentioned that the federal court is taken more seriously is because they're willing to go out on a limb and they're willing to say, we're not going to put up with this. You have just violated a court order a couple of times. You've gone against everything that we set out, and you're disregarding the court. So, and the state court, those of us who practice there, I think we can say that very often there are a lot of things that happen there that you just kind of shake your head and go, oh well. A quick example in state court, one of the senior judges actually said in open court, well, if the plaintiff's attorney send me a motion and the motion isn't opposed, or the borrower, the defendant is pro se and doesn't respond, I grant the motion. I'm not kidding. I grant the motion. Doesn't matter what it is. Now that's interesting. So that's not the kind of thing we see in the federal court. They're very, very serious about this.
I understand being serious, but let's admit it, when they're sitting down for these mediations, it's a lender and a borrower, whether they're debtor in state court or not. It's still a lender and a borrower. The golden rule still applies. Those who have the gold still get to make the rules. So if you're a lender and you have a borrower and the borrower has X income and you look at them and go, it's not enough, don't you end up with the same result? It isn't going to work?
Possibly.
They're doing what they should have done in the first place, is look at the quality of the borrower, that in retrospect, that they wouldn't have loaned them the money in the first place, it wasn't qualified, so now they're doing it trying to get a house back.
I really think that you guys and what you do, you are basically you oversee Custer's last stand. I mean, if you stop and think about it, this is their last opportunity, if they're going to keep the house, to play let's make a deal. A major portion of the ones I see are either debtors who have been lost a job and got behind their payments and then they couldn't find anybody to talk to. Or they're people who, I agree with your comment, when they made the initial underwriting, they never qualified in the first place, although people told them they did. And let's admit it, people used their homes for piggy banks for years in Florida when the value kept going up. And then they got themselves strapped with second mortgages they couldn't afford, let alone the first mortgages. So most of the people, I would say 99% of the people I see in bankruptcy are really serious people, hardworking people, honest people who are in way over their head. And very honestly, some of you have actually sat through 341 meetings with me. I will look at her straight in the eye and tell them, give the place up, move out. I mean, it really bothers me. I'm old, but when I see people sitting in front of me who are 10 years older than I am, and they're in a house where their mortgage payment is 50% of their gross income, and it's using both of their income, husband and wife, and they've already went through $100,000 of their retirement plan trying to keep this house afloat. I look at them, I stop, I look at them straight in the eye and say, stop. And look at each other. If something happens to either one of you, what position are you leaving the other person in?
Terry, I think what I'm hearing, and I think we all are, is that you have to look at the situation in a realistic way at the moment at which you're dealing with it. What happened in the past could be important, yes, but where you are at the time, and he's talking about, you know, the 341 meeting, the meeting of creditors, and in a Chapter 13, the trustee actually conducts the meeting of creditors. It's very different from a Chapter 7, where it's just different from a Chapter 7 because the trustee is looking for whether or not the plan is going to be effective, and he's looking at very realistic point of view. Is this debtor or debtors going to be able to sustain the plan, get it confirmed, make the payments, and is it realistic in their general life? And I know when I've talked with Terry, I think he looks at it not just from an accounting standpoint, he's actually looking at the individuals, the people. Is this good for the debtors to really continue this process? A lot of very good debtor lawyers are the same way.
Yep.
They're extremely realistic. And I know a number of them because they're in the room.
Now, let's
And-
talk a little difference between Lori and I. And in our jurisdiction, the mediation fee is paid directly by debtor or creditor, or split. In Lori's jurisdiction, the mediation fee is paid through the trustee, which also results in a trustee fee being put on top of that. Also, in our jurisdiction, if they go to a mediation and they're successful, we allow them to modify their plan and then take that mortgage back outside if they wish. In Lori's jurisdiction, she requires them to keep it in. Okay? Also, in our jurisdiction, we will not confirm until the mediation's done. My position on that is they're here because of this mortgage. We really don't know where they're going until that mediation is done. Because in many cases, if you guys write down they've reached an impasse, then the debtors are probably going to surrender the property. Or if they can really afford the property, they'll pay the arrearage and pay the attic protection payment. They tried that, didn't get a modification, they move on. And what we're looking for from you is just get the damn thing done.
Right.
I mean, again, I'm a plumber. Push the stuff through the system. I get out my plunger, you know, try to keep it moving. And that's what we're looking at from the mediation process. And I know you guys are as frustrated as we are when you can't find a lender, or the lender changes, Last week we wanted these documents, this week we want these documents, next week we'll want something else. And I don't know how I can help you to get lenders to get those requirements out there so you can understand them. Lori will confirm a case with the mediation still going on, which means a lot of those cases are going to have to get rehashed down the road.
Right. Does anybody want to go over those kinds of things? Because if you're not bankruptcy practitioners and we're talking about confirming a plan and then, or, you know, having to amend the plan after it's already been confirmed, in this jurisdiction, generally the confirmation hearings are continued until there's an idea as to whether or not there's going to be a modification or not. And one of the key issues there, of course, is that the property may very well be surrendered. And again, remember we looked at that. We looked at the plan, the model plan, and in the model plan, the debtor was going to make that, you know, $1,400 and some, you know, 31% of their gross income, until either the modification comes up with something like that, or it's not going to happen. Then generally, Terry is still on the hook, receiving payments from the debtor, holding them, paying them out to the creditor if identified. And then if everything has to change so that let's say the plan has to be amended, maybe we can talk a little bit about when a plan would be amended and when it wouldn't need to be amended.
Well, if you're going to change your intentions on a secured creditor's treatment, it has to be amended. And it's best, if a plan is not confirmed and the debtors decide going into, prior to confirmation, if the mediation has reached an impasse or it's failed, And they can then say they're going to surrender. At that point in time, if they say they're going to surrender, when they complete their bankruptcy, that debt is gone. That house is gone. And I actually, you guys probably don't appreciate this. I actually encourage debtors who really cannot afford their mortgage. If you want to hold, try for a modification, put in your plan you're going to surrender the property unless modified. Because I think when they get to the table with you guys, if the lender is sitting here going, if I don't make a deal, I get the property. And lenders do not want properties now. Maybe changing in a year or so, but they don't want them now. They've already got all they can handle. I really think it becomes a much better mediation process when a lender is sitting there going, if I don't make a deal, I get the property. Yes,
Are you talking about on the plan?
on the plan.
Because your counterpart won't let us do that. Not at all.
I'm not responsible for my counterpart.
And, you know, that's a very key component. And on the slides, you'll see we get to the point toward the end here where it says jurisdictional differences. And there's a lot of information that's here regarding model plan and payment to creditors and all of that. The jurisdictional differences are really significant. Within the same area, John Waggy works completely differently, not completely, but differently from the way Terry works. So if you're in a mediation, find out who your trustee is, because it's going to make a difference with respect to your understanding of how, for example, how quickly you want to get your mediation set. So there are a number of issues that come into play there. Well, let's talk a little bit about fees. The court, of course, sanctions the first mediation 2-hour fee at $350. After that, it's your hourly rate, and it's split between the debtor and the creditor. What happens, for example, if a debtor doesn't make the payment to the mediator? Could those fees, the debtor's fees, be put into an administrative expense? And if so, how would you go about doing that? Sorry.
I would have a significant issue with that. If we're sitting here in a plan and the debtor is moving forward because he wants to mediate or modify a mortgage and he can't afford to pay the mediator's fee,
Okay, then.
I might question the feasibility of this plan, possibly.
That would be a little component on the unfavorable recommendation consideration.
Well, yeah, why are we even moving forward? Either you're
Okay.
playing or you're not playing. And if you can't afford to pay the mediator's fee, then why are we moving forward?
Okay. What would happen if the creditor didn't pay the fee? Then anything that you...
The creditor wouldn't pay the
Yeah,
fee?
what would happen there? I mean, obviously, the mediator would probably have to.
The mediator could probably put in a fee application with the court. But, I mean, hopefully
right.
those are, I haven't seen one of those yet. I'm not
Okay.
saying
Just checking.
we wouldn't, but,
All right. All right. Are there anything else? We were going to touch on a few other things.
what would you like me to touch on?
Okay.
Terry, can I ask you a question?
Yes, we're still using 6% in our calculations. First of all, trustees' fees are based on monies received. So the maximum fee a trustee can take is 10%. And that is to cover our cost, all right? Like I said, I have 40 people working for me. If a trustee receives $1,000, his maximum fee is $100. I'm only dispersing $900, but my fee's $100. That's where you get your 11%. It's what we receive, not what we disperse the fees based off of. So if I get 100, I can only disperse 90. In my case, 94. But
Okay, another thing I think to mention too is when a debtor decides in a plan to pay in or outside the plan and the effect of that. because if they pay inside the plan, they're going to be charged the additional fee.
And our judges in Tampa decided, when the law changed in '95, that they got tired of the debtors completing cases, paying their arrearage, but they hadn't made a mortgage payment in 3 years. And they were getting out of cases, and then they're refiling again because the new deficiencies. So our judges said that if you're paying it in the plan, the stay is in place. If you put in the plan that you're not paying it in the plan, the stay is not in place, which means you're on your own. And if you complete your 60 months payments to the trustee, any fees during that 60 months are gone. You are current. So that's why, that's the offset.
Okay, well, that's quite significant.
That's, if you want to play outside bankruptcy, go play outside bankruptcy. Have a nice day. If you want to play bankruptcy and get some protection from your creditors, there's a cost to that.
Okay, thank you. We're getting toward the end of the time, I think, aren't we?
Yeah.
All right, here is the application that the court has set out for you to apply to the court to be on the panel of mortgage mediators in the Middle District. And it's on the slide, as you can see. It's also included in your materials. I'm trying to remember. It might be both. I think we've got copies in there. Yes, we have it. And I believe it's also on the CD. Is that right?
Correct.
We think so. They're all running together now, even though. We're right. And it's already, and it's on the website.
Well, as I said, in our jurisdiction, you can actually take the mortgage outside. But what I'm hearing from most lenders is most lenders want an order approving the fact the debtor has entered into an agreement with them. I'm seeing that's not a court requirement, but a lender requirement in most cases.
Is there a separate order on the plan, or can you just,
No.
based on that, you can just modify the plan and file that?
Like I said, in our jurisdiction, you can take it outside if you want. But we tell people, once you reach if you're at a mediation and you guys reach an agreement, as soon as you know you have an agreement, tell us. We will quit making all payments to the mortgage company until you tell us the amount. Because as you guys know, and you might not be involved after the mediation, but in most cases, or in a lot of cases, where they make that payment during the trial period may not be the same place they made it prior to the trial period. So once there's a mediation, once a modification has taken place, or at least a trial period, we want to know, we want the information so we can then make the payment to the right place in the right amount at the right time.
So before that all happens, or in connection with that, does the plan need to be modified?
No, because our plans and the order establishing duties allows the trustee to modify the plan to make the required mortgage payment. Even in cases where they're just paying the adequate protection payment and the arrearage, all a lender has to do is file that notice that the payment has changed from $980 to $979 or $997. We just automatically make that and send out the debtor saying your payment's increased.
And that provision is in the original order?
It's in the original order establishing duties.
On the mediation? Yes?
It isn't in the mediation, but it affects, the order establishing duty and the order confirming plan both have wordings which says if mortgage payments change, the trustee and the debtor can just adjust their payment to cover whatever payment's required. So we don't need an order.
Two separate orders, and then the mediation order is the third order. So there's three separate orders that you're talking about.
See, and you guys thought this was simple. It was going to be.
And I got
just-
13,000 cases like this happen every month, so that's why we have those ridiculous fees,
Yeah, those
The
ridiculous.
lender's lawyer would want to advise their client as to those things, right? You think?
I would like the lender's lawyers just to file a damn claim in the case so I can make payments.
All right. Okay. I think are we at about where we could go on for a long time here. Okay, excuse me. All right. Are there any more questions for Terry? All right. Oh, Ziona.
She can't ask a question. Okay, go ahead.
Watch me. Taking that mortgage modification immediately out of the plan makes me think about the Orlando Bank of America case. So that's where the danger is of.
And Ziona, very honestly, we have seen people, well, we're not going to pay your ridiculous trustee fee, we're going to take it out of the plan. They take it out of the plan. 2 months later, the lender who signed the agreement, even though they made all the payments on time, says, oh, we didn't make the payments and you didn't make the payments and we didn't receive them and the deal's off. If you keep them in the plan, I will guarantee you, you've got a judge looking at those people going, wait a minute. You said, here's the trial mod. The trustee got the money, the trustee made the payments. He can show me that, and I trust the trustee. Because I have no reason to lie to him.
So I
And-
think it's worth it, paying you your.
That's what I think, but I'm not, I'm not a brilliant person like most attorneys are.
Right. All right, the other part of it is once you make the commitment to pay in the plan or outside the plan, you have made the commitment.
You're either in or you're out.
You're in or you're out, and you're not going to come back a couple years later or when some fiasco occurs and say, oh, wait a minute, now I want it paid through the
Do
plan.
you trust the mortgage companies or you trust the trustee? Make up your mind.
That is a good way to end.
All out and refile, that's all we do.
Yeah.
Well, all right.
That's what happens.
Or start over again. Yeah, you'll have to come back in. That's another tactic, which is a good one. And there's a lot of
And
different.
that's always a choice in Chapter 13. The nice thing about Chapter 13, you're not in prison. You file Chapter 13, you can leave anytime you want.
And that's important, the difference between a 7 and a 13 for those of you who don't practice in the court, because when you're in a 7, you're in a 7, which one might call prison. You have somebody who's taken over your estate, and that trustee runs it, and you have to deal with the trustee with respect to what you thought was your property. In a Chapter 13, if you want to dismiss the case, you can dismiss the case.
If you forgot about that $1 million home you own on the beach up in on the Outer Banks, in a 7, too bad, the 7 trustee now has that home. In a 13, the 13 trustee can go, "Oh, okay, it's my home, you gotta pay it $1 million. You go, I dismiss.
Yeah, I quit. Okay, bye.